Start. Welcome everybody to this session of the Younger Comparativist Committee within the annual meeting of the American Society of Comparative Law. It is really an honor to have this slot within this very important conference. And it is also my pleasure to introduce our speakers today. The first speaker we have is Michael Da Silva. He's postdoctoral fellow in the Faculty of Law and at the Institute for Health and Social Policy at McGill University. And Michael will speak about the feasibility and the value of rights, or American jurisprudence through the comparative theorist eyes. Our second speaker will be Ioannis Kampourakis. Welcome, Ioannis. He is a postdoctoral researcher at the Erasmus School of Law at the Erasmus University in Rotterdam. And he will talk about protecting national security, whistleblowers in the US and within the European Court of Human Rights, the limits of balancing and the social value of public discourses. Last but not least, we have Emre Turkut. He is a doctoral researcher at Ghent University and day-to-day visiting fellow at the Center for Fundamental Rights at the RT School of Governance. Welcome, Emre. He will speak about emergency powers, constitutional self-restraint and judicial politics, the Turkish Constitutional Court in an authoritarian setting. I'm also pleased to announce that Emre just has been awarded the Colin B. Picker Prize in Comparative Law. We will have a prize ceremony on Saturday morning, but Emre is one of our honorable mention for this very important prize in comparative law. So please join me in congratulating Emre for this achievement.
Thank you so much. Thank you so much.
And there was supposed to be with us also Esther Bodnar, but unfortunately she can't join us for personal reasons. And so I think we are three of us and we can start our panel and have a fruitful discussion. So please, Michael, the floor is yours.
Hi, thanks a lot. I'm speaking to you today about with a paper called Defeasibility and the Value of Rights. I'm going to try and do the old screen share, and I'll ask the classic question of whether you can see it yet. You see my? Okay, perfect. And so as Antonia said, there's a subtitle to this paper, and it's "Or American Jurisprudence Through Comparativist Eyes." And the nod here is to the fact that I'm largely in this paper responding to my good friend Jeff Siglet's recent paper, American Rights Through Canadian Eyes. Those of you who spend a lot of time in rights theory will know that he himself is nodding to a classic HLA Hart paper looking at jurisprudence through yet another series of eyes. So we're keeping an iterative process here. And I'm going to speak today predominantly in a critical way in a response to Jeff's paper. And what Jeff does is he defends an absolutist conception of rights against a critique that these absolutist conceptions distort democracy. And this is a critique that gets raised by the work of Justice Breyer, by Vicky Jackson, and by Jamal Green. And much of what I'm going to say today is quite critical of Jeff's defense of absolute rights theory. But I should note that I actually really enjoyed Jeff's piece, and one of my minimal goals here today is to sort of convince you to read it. So I've actually provided a link to the SSRN version of that paper, because what I think it does really well is help us understand why the absolutist conception of rights is so compelling in a way that's really deeply grounded in the actual law of both the United States and Canada, in a way that I'm not going to be able to get into sufficient detail in my 15 minutes of talking today. So in the short time, a lot of the things I want to do are still quite a few. I want to provide a brief overview of at least the argument for proportionality in American jurisprudence on democratic grounds that is provided in Jamal Green and Vicki Jackson's work. This is an argument that absolutist conceptions of rights undermine democracy by distorting it in several important ways. And then provide a brief overview of Sigalet's critique of Green, Jackson, and Breyer, who I'm bracketing here because I think the argument is arguably less developed in Justice Breyer's otherwise helpful comments. And you'll see that he has a view that in fact, it's the proportionality analyses that are going to have these distorting effects. But then I'm gonna turn back and continue the dialectic further and provide two different critiques of Jeff's work. One focused on conceptual questions about how we evaluate different modes of interpretation in comparative constitutional law in rights theory and perspective. And second, a sort of broader question about what we can really learn about comparison of the United States and Canada when we're talking about how we should interpret rights more broadly and what rights are. A lot of this debate is going to focus on what constitutes a pathology in our treatment of rights in constitutional liberal democracies. And so it's worth starting by just reminding ourselves of what are the specific pathologies of absolute conceptions of right that Green and Jackson identify. And they're very detailed arguments, but I think we can summarize them as having two main forms. One, absolute conceptions of right fail to account for reasonable disagreements about rights, about their content, about which ones there are, et cetera, et cetera. About any good question about rights, there's reasonable disagreements about them. And also they tend to fail to account for the importance of institutional solutions to those agreements. So a way of putting this is to say that failing to account for reasonable disagreement about what rights there are, about how we should understand them, what their scope and content are, limits our opportunities for non-judicial actors to discuss rights and their proper limits in regular democratic discourse. And in so doing, they not only freeze rights in the classical sense, right? That's a traditional view that people have about absolute conceptions of rights. They don't allow rights to grow over time. We might think that's fine. They have this additional problem that they tend to reify particular conceptions of rights that have questionable bona fides and that people can disagree with, and then insulate these particular conceptions of rights from democratic procedures that could help rights better reflect what rights should be, what the norms are in a community, et cetera, et cetera. If you have an absolute right and that's what the judge always must do, that's what the right is. The question's pretty much done. All we can do is ask, does this particular token fit under the types that we've identified pre-institutionally? And what's nice about, one thing that they note that's nice about the alternative views is that proportionality analyses actually offer not only an opportunity to disagree and to do this outside of judicial boundaries, but they also actually allow us to debate rights in a particular judicial fora that allow us to raise our reasonable disagreements about rights and have a discussion about their proper scope, both within the confines of the judicial setting and outside it. The second pathology then is that absolutely rights implicitly weigh values anyway. And so failing to allow some weighing of values undermines transparency, which is a fundamental value of a liberal democratic process. So the idea here is that, look, even absolutist conceptions of rights inevitably conflict. We can debate whether that's the case, but I think this is the motivating idea. And thus they cannot be realized without implicit appeals to proportionality. And this is something that I think most people will recognize, is that, you know, even in the United States, we have, I'm actually speaking from Canada, but we have examples of implicit weighing and balancing taking place. And the idea here is that actually weighing or balancing is necessary to resolve these inevitable conflicts. And that's explanatory of why we get proportionality analyses in the USA. It's not the case that they've somehow gone awry from their original absolutist conception of things. It's just that inevitably they have to weigh or balance in some way. But where you also avow an absolutist conception of rights, you raise a problem because you're being non-transparent about how fundamental public interests and how they are actually being weighed against each other. So questions about the nature of rights and the level of rights protections that citizens can expect to receive from the state become much more difficult to answer when what you're saying, all you're doing is dealing with absolute rights, but you're actually doing some under the table weighing or balancing, pick your favorite metaphor, as it were. And so they say, look, explicit use of a proportionality standard is more transparent. And one way that they do make this argument is by appealing to proportionality analyses that you see in other states. I mean, nobody takes the view that you should just import the Canadian experience with proportionality, for instance, straight into the USA. There's institutional bars from doing that, right? There's no explicit limitation clause on American constitutional rights as we see in the Canadian law. So if you're going to port it over, you're going to have some difficulties. But there's a very rich discussion of the case law that suggests that you can actually be more transparent. You can actually allow for greater disagreements in different areas that draws on comparative analysis. And they say, look, we need some sort of explicit proportionality test, and maybe something like we see in other countries might be a good idea. But in Jeff's work, he does some really interesting, makes some really interesting claims to suggest that actually what's going to be more distorting in at least the American context would be the invocation of any sort of proportionality standard. And in particular, he finds problematic the idea of the use of the American proportionality standard. He says that, in fact, proportionality analysis is not the cure for an ailing democratic rights jurisprudence in a common law jurisdiction, but it may actually contribute to its pathologies. And he has sort of two lines of argument that are each rather interesting. First, he makes a conceptual claim. He says that rights as proportionality intrinsically devalues rights. So he grants that all forms of rights analysis have the potential to devalue rights in some way, but he claims that only proportionality analyses do so intrinsically. And why do they do so intrinsically? Well, they do so intrinsically because they make rights into mere interests that can be weighed against each other. And so they're not things of absolute value anymore. Rights are, Sigalet claims, more than mere interests, and proportionality simply obscures this. Those interested in transparency, in fact, should want transparency about the relationship between rights and justice. And that relationship is one where rights are treated as having a particular form of protection that can't allow for at least regular weighing, as we see in jurisdictions like Canada. And then Sigalet argues that even beyond the conceptual claim, if we look to the case law, the invocation of proportionality analyses has this further disruptive effects in the realization of genuine rights, or your classical rights, in practice. He says American courts, sure, they use proportionality tests, and their record in doing so is mixed. But if we really want to see what a uniform proportionality analysis is going to look like, we should look to comparative law. And if we look to Canadian law in particular, we're going to see that three things happen that are distorting. First, we see a form of rights inflation, in which implausibly broad claims receive prima facie rights protection, only for many of them to then be justifiably infringed in most cases. We see, second, that judges are allowed to use moral reasoning to override rights because, all they have to do is weigh, and that's a moral analysis to some extent. And third, he suggests it undermines legislative attempts to set the boundaries of rights and accordingly does not lead to proper dialogue between the courts and legislator, and thus doesn't allow the legislator to help set the scope of rights. So if you're concerned about non-judicial actors not being able to set the scope of rights, Jeff says, you should actually be concerned about the way that allowing all the weighing to happen in court doesn't let the legislator play its proper role in setting the standard of rights. And he says, look, this is a lot worse than the American status quo. The conclusion that he draws from this is that rights should be thought of as morally absolute, even when they are subject to reasonable disagreements about the scope of their requirements. I don't think he can draw this conclusion, even if the foregoing is true, but I think there's also reasons to question both his lines of argument. I won't say much about the dialogue theory claim, that one about the proper role of the legislature, because I think that that's a strong argument, but one that takes us into substantive discussions we don't have time for today. But I do think there's reason to question both his conceptual claim about the value of rights and whether the distorting effects that he identifies, to the extent we can identify them in Canada, are intrinsic to proportionality or to any form of proportionality that might come into the United States. And so I really think that if that's so, we can question whether his evidence supports this conclusion. So my first concern is about the value of rights. My charge is that the claim about that absolute conceptions of rights are preferable to conceptions that allow for proportionate infringements isn't in fact a lesson to be drawn from his claims, but as a presupposition of his critique. And so my view is that absent a neutral conception of rights, claims that non-absolutist conceptions intrinsically devalue them might not withstand scrutiny. And I charge, in fact, that he seems to presuppose an absolutist friendly conception of the values of rights. So the closest he comes to identifying his standard for what it means for a right to be valued is when he says that Jamal Green devalues rights by reducing them to defeasible interests. He then elsewhere states that the Canadian approach treats all rights claims, including fundamental rights claims, as mere policy interests, and that this devalues their status. And he actually thinks that a lot of the problems we see in US cases like Citizens United are also problematic because they treat rights as defeasible interests. Yet, I want to suggest that neither treating rights as interests nor treating them as defeasible obviously is equivalent with treating them as less valuable if you don't already accept an absolutist conception of rights. And so to do this, I just want to briefly outline two alternatives that suggest that rights just are defeasible or simply are a kind of interest. And so proportionality analyses treating them as such in no way devalues them. So first consider just the idea that all rights are a kind of interest, a special kind of protected interest. The view, when we talk about what rights are for, one of the two dominant views is that they are just to protect our interests in the first place. Now, this doesn't naturally mean that all they are is interests, but it does lend itself to the view that rights are a special kind of protected interest, which is itself a reasonably mainstream conception that we can't just throw out by definitional fiat. And if this is true, treating rights as interests in no way devalues them. Instead, it speaks to a feature of the choice architecture that best justifies the rights claims, namely the interests at bar. If, moreover, rights are interests in proportionality analyses weigh interests, an interest being capable of being overridden doesn't make it less valuable. It's just the fact that other interests are in the choice architecture. Indeed, the weighing process itself depends on the value being provided to the right prior to the analysis. What it means to have a proportionality analysis in this view is we already have the value sorted out and we weigh them against each other. Now, Siglet then further claims that non-absolutist conceptions err because legislatures are presumed innocent until proven utilitarian, a just excellent choice of phrasing. But an alternative deontological theory of rights also allows rights to be weighed in a pluralistic universe without being devalued. And this is a view in which rights just are defeasible by definition. Consider For instance, the view that we call threshold deontology. This is not a utilitarian theory, it's a deontological theory. And it says that morality demands the protections of all rights, but there are circumstances where fulfilling the right would make so many negative outcomes so as to go beyond a threshold and would make it all things considered rightful not to fulfill the right in question. Sorry, I lost this. If this is the case, the value of the right remains the same even when outweighed. And if this is the case, then to say that a right can be weighed is defeasible is not to say that it's being valued less, it's just saying that there are circumstances where rights aren't what, fulfilling rights isn't what we all things considered ought to do. This doesn't mean that their value disappears. In fact, on threshold deontology, you have certain duties to recognize the fact that what you did was wrongful in some way. You should pay compensation to the person who you have wronged. You should feel somewhat bad about the fact that you weren't able to fulfill the right. But it's the case that, all things considered, fulfilling the right wasn't the most valuable thing you could have done. And if this is true, then it isn't the case that by treating rights as defeasible interests, we treat them as in some way worse. So if this is true, then what it means is that proportionality theorists might not disvalue rights as all. Indeed, they might not distort rights by invoking their own moral reasoning, but might just be recognizing the plurality of rights in the first place. There are a lot of important things in the world, and we need to weigh them against each other. Sometimes particular rights claims won't win out. And this view also seems to make conflict inevitable, at least the last view. So an absolutist conception that does not permit any weighing is going to be off the table. And this goes into my concerns about case selection, which I can only really outline in brief here, but I think are worth noting. First, I think there's reason to worry that the United States and Canada are particularly good cases for determining whether proportionality is going to be, proportionality or absolutism is the best conception of rights, all else being equal. But it's worth also remembering that any pairwise comparison probably isn't going to be able to tell us what the value of rights is, all things considered, and thus what view of interpretation we ought to make. And so, beyond that, though, I think it's worth noting that the data we do have, the fact that we do have this history of comparison in the United States, this history of implicit invocation of proportionality analyses in the United States, suggests that it may be the case that absolutism is not a live possibility on the table in the USA. So when we do a comparison between when we're doing a comparison between live constitutional possibilities, it may not actually be the case that an absolute conception is available. So really, we might not be able to reach the conclusion that we ought to adopt that view. I also noted that there's textual differences between the two regimes that make comparison difficult. But the last thing I want to note is that issues with Canadian case law might not be attributable to proportionality as such, right? We have a lot of different jurisdictions where proportionality takes place, and it's not clear that the distortions 1 through 3 that we saw on the earlier slide are always attributable proportionality, as opposed to particular features of Canadian law and of the Canadian judicial decisions. So for instance, Sigalet makes much of the fact that Canada recognized a prima facie right to have child pornography and then just said, oh, but look, it's justifiable to criminalize it. Well, it's consistent with a threshold deontological view, for instance, to say, no, there is no prima facie right there. They've just got the scoping of the right wrong in the first place. There's nothing inherent about proportionality as such that says you have to give really broad conceptions of right. That's just something that Canadian courts have done that I think we can all suggest is problematic no matter how you value rights. So this doesn't mean absolutist conceptions of rights are wrong or that the United States shouldn't accept them. All it says really at the end of the day is that we cannot yet assume that the democratic case fails, And that when we're comparing whether we ought to adopt proportionality or absolutist conceptions of rights in a given jurisdiction, further analyses of live possibilities for judicial treatments of rights are the ones that we should be evaluating in light of the concerns raised by Green, by Jackson, and Sigalet, and that it might be helpful to have a neutral conception of the value of rights when we compare the different conceptions and their distorting or otherwise pathological implications. Thank you.
Thank you very much, Michael, for this very inspiring presentation. I'm looking forward to open the debate on your paper, but now I give the floor to Ioannis Kampourakis. Please, Ioannis, the floor is yours.
Yes, thank you very much, Antonia, and well, thank you all for being here, and thank you for the invitation and for the organization of this panel. I mean, of course, it's a classic thing to say. It's a bit of a pity not to be there and do this like really physically, but nevertheless, it's a great opportunity to be able to be at the same time virtually in the same room with people from all over. So the paper I'm going to present to you here today is drawn from my PhD, from my doctoral thesis, and it's actually now currently forthcoming in the Yale Journal of International Law. So in this paper, I explore the constitutional considerations that arise from whistleblowing within the setting of national security. So the fundamental question is how to strike a balance between the social value or the institutional value of whistleblowing and the protected public interest that lies in state secrecy. So in order to articulate my normative argument, to which I'll come to towards the end, I first compare the case law on employee speech in the United States and in the European Court of Human Rights. And I conclude that it has focused excessively, let's say, on the subjective aspect of whistleblowing as an instance of individual expression and freedom of speech. So contrary to this predominant subjective liberties paradigm, my argument is that whistleblowing should be understood and eventually also protected against criminal sanctions in its institutional dimension, as a counter-institution, to adopt the system theoretical terminology, or more simply an obstacle to the expansive tendencies of the security system. Can you hear me? I just got a message, a notification that my internet connection is unstable. It's okay?
Now yes.
Okay, cool. Right, yeah, like I said, my argument goes contrary to this like subjective liberties paradigm, like focusing on whistleblowing as an instance of freedom of speech and individual self-expression, and focuses more, which is, as I will show, how the courts perceive whistleblowing in most instances, and instead focus on the institutional dimension of whistleblowing as an obstacle to the expansive tendencies of the national security system. So the social and the constitutional value of disclosures in the public interest is not limited, in my opinion, to them being an instance of freedom of expression, but it rather lies in the function whistleblowing performs for the accountability of public institutions and the maintenance of the democratic character of secrecy, of state secrecy. So I will show that although this understanding hasn't become decisive, it already permits this understanding of whistleblowing social value, let's say, or institutional value, already permits existing case law, especially in the case of the European Court of Human Rights. So precisely building on this development of the case law, especially in the European Court of Human Rights, I proceed to outline an institutional model of whistleblowing protection, which in a nutshell, as I will show at the end of the presentation, entails shifting from balancing between subjective rights and the public interest to eventually assessing the legitimacy of the disclosed activity, the legitimacy of the secrecy at hand. So first, I would like to say just a few words about how the legal framework against national security whistleblowing is generally very strict. So in both the US, which is probably something that one could probably already imagine, but still it's worth mentioning that in both the United States and in Europe, the protections and guarantees for national security whistleblowers are very limited. And disclosing wrongdoing within national security apparatus internally is exceedingly difficult and often very convoluted and sometimes also practically impossible, while unauthorized public disclosures of confidential information, say to the press, face as a rule criminal sanctions. So on one hand, of course, a remedy to this situation would be to introduce more robust internal procedures for reporting wrongdoing. And that's indeed important. On the other hand, it's also worth thinking that such mechanisms of internal reporting will be, in fact, least helpful when they are most important. That is to say that when disclosures expose systemic abuse and lack of accountability at the high degree of the high ranks of the hierarchy, then it might be unrealistic to expect from a system of internal reporting of wrongdoing to fulfill the promise of accountability. So I suggest that in that case, a further step in the direction of institutionalizing a democratic secrecy or designing the institutions in a way so as to promote democratic secrecy is to also expand freedom of speech rights for whistleblowers who disclose to the press when internal means fail them or when they are bound to fail them. So in that sense, whistleblowers function in that particular situation as a safety valve, extra safety valve for guaranteeing the public accountability. So now in let's say a second part, I would like to talk a little bit about the freedom of speech rights for whistleblowers as they have been perceived and understood in the different jurisdictions that I examined, the US and the European Court of Human Rights, where, as I will show, in both instances, whistleblowing in government is conceptualized as a conflict between subjective rights and public interest. So in the US, a series of constitutional cases, including Pickering, Connick, Garcetti, and Lane, concretized a balancing test about whistleblowing in government. And following this test, employees have to first be speaking as citizens, and that they do when they uncover wrongdoing, unless the speech itself is ordinarily within the scope of their duties. So unless they are like detectives or police officers and so on. So in general, let's say, when they uncover wrongdoing, they do speak as citizens, but they have to. So that's it's also not obvious. It's not irrefutable. The second issue is that the issue they bring to the surface has to be of public concern, which may in general be the rule for whistleblowing cases, but it's also not irrefutable, especially if the motive of the whistleblower is taken to be some personal grievance, so motivated by personal antagonisms and so on, then the issue might not be considered of public concern. And the third thing is that the disclosure must satisfy a stricto sensu balancing, meaning whether the interest of the employee to comment upon the public upon the topic of public interest outweighs the interest of the state in guaranteeing the efficiency of its services. However, this balancing test that I just briefly now outlined, that applies in the case of in government in general, has not really applied for national security employees. Well, as one could probably imagine, national security renders the invocation of freedom of speech even more difficult than in other sectors of public employment, and what we would ordinarily understand as speech might not even be considered speech, but rather a theft of classified information. So this might be, I suggest, attributed to the confinement of freedom of speech in a relatively subjectivist reading that disregards this more institutional, the social value of the information disclosed by the whistleblowers, the value of the information for public debate. On the other hand, going to the European Court of Human Rights, the court has progressively there been placing increasing emphasis, let's say, on the social value of public disclosures. So a key case in the European Court of Human Rights is that of Gudza versus Moldova, which established a set of criteria for the resolution of conflict between the duty of loyalty and the freedom of expression for public employees. And these criteria include the information being accurate and authentic, that the information must involve the public interest, and that it has to be disclosed in good faith. So again, the whistleblower should not be motivated by personal antagonisms. Initially, that is, there was a balance between more subjective criteria, such as that of good faith, and objective criteria, such as that the information being of public interest. However, the court has progressively advanced a more objective institutional understanding of the conflict around public disclosures of wrongdoing. And how did the court do that, this more institutional understanding, which I'm also advocating for, let's say, by accentuating the importance of the criterion of public interest and undermining the most clearly subjective criterion, that of good faith. So in several of its decisions, the court has advanced a functionalist reading of freedom of expression, balancing the importance of the information for the public debate against the duty of loyalty. And there's some cases I can mention later if someone is interested. And this highlights the preoccupation of the court to protect the facets of Article 10 that function as safeguards for democratic deliberation. So the protected interest in whistleblowing then actually becomes public deliberation and the right to know of the citizenry, as opposed to the individual self-expression of the whistleblower. So the developments of the case law of the European Court of Human Rights, even if they are not conclusive of a general distancing from the subjective liberties paradigm, are in line with my argument that the value of whistleblowing is that it enables public accountability and the democratic control of security politics. So as such, it also fuels my, my suggestion for an institutional model of whistleblowing protection, to which I will go now. So I will take just a few minutes and I will conclude with that section to outline the, let's say, the more normative aspect of my paper. So which builds on the comparative section that I discussed before. So the premises of the normative model that I suggest are that first, it is a principle that arises from both European and US constitutional traditions and institutions that the limitations to the right of the people to know about government's activities must be strictly defined by law, let's say classification law, that must be necessary to achieve their purpose of protecting national security, and they have to be proportional to the detriment inflicted on open public deliberation. So in other words, to put it very briefly, in liberal democracy, state secrecy must be the exception and not the rule. Also, a second premise is that for secrecy to be legitimate secrecy, the citizenry must be aware of the existence of a secret, even if the precise information is not known to them. But at least they know that there is a secret there. So there is some, so secrecy cannot cover complete illegality or wrongdoing. So with these things in mind, suggesting that, put it that like this, balancing national security interests with freedom of speech, which is the current exercise, is predicated upon the legitimate character of these national security interests, based on the premises that I just mentioned also before. But the question is this really the case when the disclosures reveal wrongdoing, misconduct, corruption, or going beyond the democratic mandate in like completely unauthorized by democratic elections and a representative system of government policies or practices like, I don't know, enhanced interrogation or whatever? So sanctions like those included in the US Espionage Act, for example, or in the UK Official State Secrets Act, serve indeed the legitimate aim of preventing harm to national security, safeguarding state secrets, and maintaining trust in government operations. But if it can be established that the secrecy under consideration was itself illegitimate, meaning that it covered illegal activities or activities of contested legality that were completely insulated from public accountability, then there is no legitimate interest that this instance of secrecy could protect. As such, no criminal sanctions, I suggest, should apply to whistleblowers that publicly disclose this kind of information. The major counter-argument to this thesis is that of harm to national security. So the idea is that, well, even if the disclosures disclose some type of illegality and or corruption or whatever, it still might inflict harm upon national security. But indeed, this can be claimed even if the secrecy was itself illegal. But I think this argument has to be rebuked because it essentially places the executive's determination of national security interests beyond the rule of law, beyond the reach of law. So safeguarding state secrets to the benefit of national security interest is legitimate only to the extent that it respects the restrictions placed by democratic governance, separation of powers, and the rule of law. In other words, state secrecy cannot be a ticket to unaccountability. However, with regards to employment-related sanctions in cases of whistleblowers disclosing illegal, let's say, secret practices, the government still remains the employer. So according to the European Court of Human Rights, the employee has a duty of loyalty, reserve, and discretion to the employer. And in the US as well, according to the Pickering case and its progeny, the government has a legitimate interest in guaranteeing the efficient functioning of its operations. Therefore, the legitimate purpose of the sanction still remains in that case, irrespective of the illegitimacy of the secrecy involved. So the criterion in this case for the particular balancing exercise should be whether the whistleblower exhausted the internal means of reporting wrongdoing, or whether such means did not exist, or whether it would have just been futile to pursue reporting through internal procedures because, well, it wouldn't have, nothing would have happened. If the whistleblower could prove that case, then the whistleblower could also be protected against employment-related sanctions. Otherwise, it would be reasonable that employment-related sanctions could apply. The other question is, what if whistleblowers reveal legitimate secrecy? Well, in that case, I actually refer to them as leakers in the paper, so I draw this distinction. Well, I'm saying that in that case, the government should still be allowed to punish the employees criminally. It should not be allowed to publish the employees criminally, unless it makes the same showing that it must make for a government outsider, so to really prove the grave harm and the connection of grave harm to national security with the release of that specific information. So in general, the power of the government to prosecute for the dissemination of information should be met with high scrutiny. But naturally, of course, in that case, there can be employment-related sanctions. So just like one conclusive word with regards to the value of my normative contribution and the main points to conclude. So the first thing is that I think the focus should be, and consider it sort of like one of the things that the model I'm suggesting brings forward, is to focus on the social and institutional value of whistleblowing and its function as a counter-institution against undue secrecy. The second thing is to construct a jurisprudential model that focuses on the protection of whistleblowers against criminal sanctions when they reveal illegitimate secrecy, in order to restore accountability in the executive and to safeguard the rule of law, the separation of powers, and the right to know, which are all integral elements of democratic governance. And the final thing is at the same time also to protect legitimate secrecy through sanctions to leakers disclosing legitimate secrecy, which should nevertheless remain on the level of employment-related sanctions, and only in exceptional circumstances and after heavy justification from the government allow for criminal punishment. So this is, and I will also upload the link of it's the draft right now. The paper should come in the next month, so I will upload the link now here in the chat. Yeah, thank you very much, and I'm looking forward to any questions or and the discussion.
Thank you, Ioannis, for this very brilliant exercise of comparative law, looking at two different models and approach towards the protection of rights and towards the protection of national security. So now I will give the floor to Emre Turkut for our last presentation, and then I will open the floor for the debate. Please, Emre, the floor is yours.
Many thanks, Professor Baraggia, for the introduction, and I'd like to thank the organizers for the opportunity to present my work. I also have a number of PowerPoint slides, which I'm gonna share now. Can you all see it?
Yes.
Okay. So, well, just to give a little background to what I discussed in my article, since at least 2012, the Turkish government has increasingly moved away from rule of law standards and democratic ideals and steered the country in an increasing authoritarian direction. And especially after the 2016 attempted coup, we see that constitutional liberties and rights were suspended, and almost every corner of the Turkish society was targeted. And perhaps more fundamentally, the ruling Justice and Development Party, in Turkish acronym AKP, under President Erdogan, initiated an array of reforms to centralize the political authority and to transform the existing legal and constitutional order. And one important project for this was to establish an executive presidential system, which was based around vast powers of the president. And this presidential system was adopted in the 2017 constitutional amendments. And for many observers, the Turkish Constitutional Court could be reasonably expected to be a major obstacle to the Turkish government's far-reaching emergency policies and its drift toward authoritarianism, because the court has always been an important actor since its creation with its institutional centrality and strong powers of judicial review. But somewhat surprisingly, in the new political and constitutional environment in the country, the Turkish court demonstrated increasing deference to the Turkish government and to a certain extent sided with them in many controversial political cases over the post-coup period. So this is the main topic of the paper, and in that I surveyed the judicial politics of the Turkish Constitutional Court over the post-coup period. And the overall conclusion and argument is that the Constitutional Court adopted a play it safe strategy by having to make radical departures from its long-established standards. And the paper is divided into three parts. The first part goes way back to the political origins and institutional features. And the second part asks the question of what explains the court's judicial restraint. And the third part identifies a number of themes underpinning the court's approach by particularly focusing on its judicial behavior. And to summarize some of the things that I discussed in the first part of the paper regarding the political origins and institutional features of the Turkish court, we see that the Turkish constitutional judges have almost always inserted themselves in domestic politics by disbanding the so-called anti-secular and pro-Kurdish political parties, and by policing elected institutions. And as such, they have served as the linchpin of the Kemalist founding regime to maintain social control over the popular will. And following the rise of AKP, the Justice and Development Party, they have always been in fight with them and struck down a number of policies that the AKP brought up. For example, in a 2007 case, the Turkish Constitutional Court annulled the election of the Turkish president by the parliament. And another related case in 2008 concerned the closure case of the AKP. In that case, the Turkish court decided not to dissolve it, but stripped its public funding on the ground that the focal point of anti-secular activities. And again, in 2008, the court struck down a constitutional amendment that aimed to lift the ban on the wearing of headscarf in universities and in public, which has been one of the best known policies of the Turkish government. So as I discussed in the second part of the paper, especially from 2000 onwards, the Turkish government adopted a whole set of measures to control and contain the court's judicial activism. And in the 2010 constitutional amendments, for example, the judicial appointments to the Turkish Constitutional Court were highly centralized, and the ensuing overtly political appointments produced a remarkably ideologically split court. And in following years, the Turkish Constitutional Court faced some very acute limitations, such as direct attacks and public campaigns. And even one instance, President Erdogan invited the members of the Turkish Constitutional Court to take off their robes and engage in politics under the roof of political parties. While the 2017 constitutional amendments introduced only minor changes, they had created some broader consequences for the court's institutional independence. And all in all, the Turkish Constitutional Court was ultimately contained within an increasingly authoritarian political system in the post-coup period, and expectedly they retreated into subservience. And in the third part, I identified three themes underpinning the court's approach, and these are survival, abstention, and negotiation. The survival mode of the Turkish court marked the early months of the post-coup emergency rule, during which the court refrained from playing any meaningful role. Instead, they focused merely on their institutional concerns. The first decision of the Turkish Constitutional Court in post-coup period, I think, provides a salient example here. On 4 August 2016, just 2 weeks after the declaration of state of emergency, the court unanimously decided to dismiss 2 of its members, Alparslan Altan and Erdal Tercan. Less than 24 hours after the attempted coup, these 2 judges have been detained on suspicion of having links to the so-called Gülen movement, which was allegedly responsible for the attempted coup. Normally, the constitutional judges enjoy procedural guarantees under Turkish law, but with the exception for cases in flagranto delicto relating to their personal crimes. And the Turkish magistrate, Peace Criminal Court, relied on this very exception when detaining these 2 constitutional judges, holding that the circumstances of the attempted coup constitutes the factual and legal basis for a case of discovery in flagranto delicto for the alleged offense of membership of the Gülen movement. And in the meantime, the Turkish government adopted one of the very controversial decrees, decree number 667, and conferred the power, conferred the Turkish Constitutional Court plenary the power to purge and remove from office constitutional judges who are considered to be a member of, affiliated with, or have cohesion or connection or with terrorist organizations or structured entities. And in its decision on 4 August 2016, the Turkish court held that the Turkish Constitutional Court held that cohesion and connection does not have to be supported by any kind of evidence. Rather, an assessment of the plenary session of the Turkish Constitutional Court is deemed sufficient. And then the court dismissed Alparslan Altan and Erdal Tercan from their posts, holding that the information from their social circle and the common conviction formed by the remaining constitutional judges indicated that these 2 judges had links with the Gülen movement. This decision, of course, had a snowball effect and revealed many challenges. First of all, it provided a rather indirect constitutional review of this emergency, of this very controversial emergency decree, so challenging the dismissals of judges and prosecutors before the Turkish courts become somewhat redundant. Second, this lack of oversight by the Turkish Constitutional Court, the apex court of the country, allowed the Turkish government to go uninterrupted in the dismissal of over 150,000 public servants, by emergency degree. So rather than being caught in this in the so-called Gülenis dragnet as a whole, the remaining judges of the Turkish Constitutional Court simply pitted their benchmates upon the order of the executive and deferred to the Turkish government aggressive campaign of purging the Gülenis people from state institutions. And another broader issue showing how the Turkish Constitutional Court jeopardized its role was its reluctance to react to wide-ranging human rights violations claims stemming from the attempted coup. And initially, the Turkish Constitutional Court was floated by hundreds of thousands of individual applications, but it was markedly slow in reacting to them. And just to give you an example, by June 2017, almost 1 year after the declaration of state of emergency, the Turkish Constitutional Court had received over 100,000 individual applications, but in turn, at that time, the court only decided in 4 cases. So the court definitely utilized a number of avoidance techniques to sidestep looking into the merits of complaints. Then the court was confronted with many constitutionality review appeals lodged by opposition parties. Over the post-coup period, the Turkish government mostly relied on emergency decrees to transform the legal order. So they stipulated permanent and structural changes to the ordinary legal framework and restructured many public institutions, and arguing that these changes had nothing to do with the real purpose of the state of emergency, the opposition parties had lodged a number of appeals seeking the annulment of several post-coup emergency decrees. But the Turkish Constitutional Court rejected the argument that it could review the constitutionality of emergency decrees by being in abstracto under Article 148 of the Turkish Constitution. And as you see here in the slides, that article in principle prevents such review. But in the past, the same court engineered ways to substantially review emergency decrees, arguing that a literal application of this provision may put constitutional guarantees, especially during a state of emergency, at utmost risk. For example, in two precedent-setting cases, in January and July 1991, the court adopted a 3-tiered test examining ratione temporis, ratione loci, and ratione materia of the emergency decrees to judge whether they fall within the scope of its constitutional review powers. And if an emergency decree does not meet these requirements, it cannot be regarded as an emergency decree, because according to the court, Article 148 of the Turkish Constitution limits the constitutional review of only genuine and real emergency decrees. And as a result, in these two decisions, the court annulled a number of controversial emergency decrees that were applicable in the emergency region in Turkey's Kurdish-dominated southeast. And in 2003, the court even expanded the scope of its precedents. And in this decision, it ruled that the constitutional framework regulating emergency powers should not be confined to a number of articles which directly govern them, but rather all relevant provisions of the Turkish Constitution must be taken into account. But during the post-coup emergency rule, the Turkish Constitutional Court departed from these standards. In justifying its departure, the court relied on seemingly 2 vague arguments. The first is that the court, going back to the drafting of Article 148, noted that the constitutional drafters wanted to place emergency decrees only under ex post parliamentary control. And the second is that, as the court noted, if the court engages in such a constitutional review, like its previous precedents, this would be in clear breach of Articles 6 and 11 of the Turkish Constitution, which cumulatively prohibits state organs to exercise any authority that does not emanate from the supreme law of the land, which is the Turkish constitution. And as such, in these decisions, as well as many other constitutional challenges in the post-coup period, the Turkish Constitutional Court abstained from reviewing controversial policies brought up by emergency decrees, which form the bedrock of regime transformation and dominance. And I analyzed the decisions in greater detail in the paper, but to state it briefly, to me, these decisions appear as strategic choices and calculations by the Turkish Constitutional Court to resist impinging on the new political regime's needs. And considering at the time of these decisions that the parliamentary majority was under the control of the ruling AKP, this strategic jurisdictional change revealed that the particular political persuasion of the court was now too closely tied to the executive. And as such, this start turn eroded formal limits on executive emergency powers and represented a blank check for it to move the country toward authoritarianism under emergency rule. And finally, we come to how the Turkish Constitutional Court negotiated between political pressure and individual justice in cases of heightened political significance. And as I note here, this was a concept that hitherto shaped the approach of the court in constitutional complaints, especially, as I said, in cases of heightened political significance. And just a brief background to the constitutional complaint mechanism, that mechanism was originally introduced in 2012 in Turkey and got off to a very good start in the country. And the court issued a number of freedom-serving decisions. For example, in 2012 December, in a precedent-setting decision in Mustafa Balbay judgment, the court found the pre-trial detention of a journalist and a member of the Turkish parliament to have violated his right to representation. And two other highly praised judgments were the Twitter and YouTube judgments in 2014, in which the court lifted the governmental ban on these social media giants. So these judgments, among many others, in highly critical cases, increased the court's popularity and garnered much praise from domestic and international circles. But in the years to come, especially after the 2016 attempted coup, the Turkish Constitutional Court sent increasingly contradictory signals in individual complaints. First came the complaints filed by the Kurdish opposition leaders, in particular pro-Kurdish HDP chair Selahattin Demirtas. In November 2016, pursuant to a constitutional amendment lifting his immunity, parliamentary immunity, which was also supported by the Turkish Constitutional Court, Selahattin Demirtas was detained being accused of leading a terrorist organization. He, of course, lodged an individual application with the Turkish Constitutional Court, relying on the much appreciated precedent in Mustafa Albay, in which the Turkish Constitutional Court set a very high standard regarding the detention of a parliamentarian, holding that it must be based on concrete facts, proving the existence of a much more pressing public interest, outweighing the interest in the exercise of the right to be elected. And in turn, in Selahattin Demirtas case, the Turkish Constitutional Court waited over a year to rule against his release. What is quite interesting here is that the court somewhat admitted that it resorted to an exit strategy of factual distinguishing by noting that Mustafa Balbay's detention on remand was 4 years and 5 months, while the detention of Selahattin Demirtas was only 1 year long. So the court found Selahattin Demirtas' detention was not worthy of judicial review. And such a fragmented approach and selective justice persisted over the post-coup period. In January 2018, for example, the Turkish Constitutional Court found the detention of 2 journalists Mehmet Altan and Şahin Alpay, violating their right to liberty and freedom of expression, because their detention was solely based on a number of newspaper articles that they wrote. And after the leading Altan and Alpay judgments, which garnered much praise, we were expecting that other applications raising similar complaints would be speedily addressed by the court. But the expectation and the reality seem to be once again, poles apart. In May 2019, the Turkish Constitutional Court eventually heard a group of cases deriving from similar causes, namely the detention and prosecution of journalists and civil society leaders, where the Turkish prosecutors relied on everyday activities as an evidence of supporting terrorist organizations. And in 4 cases, the court found violations, but in other 7, the court did not find any violations or rejected them. This group of cases, again, I discussed them in detail in the paper, was a clear example of the fluctuation in the Turkish Constitutional Court's post-coup performance in upholding the human rights standards in cases with heightened political significance. For example, juxtaposing the European Court of Human Rights findings in some of the applicants' cases, especially in the Osman Kavala case in December last year, with what the Turkish Constitutional Court found in their individual applications, reveals a stark contrast. And even in cases in which the Turkish Constitutional Court was able to overcome the political pressure, a peculiar trend emerged, the use of dissenting views by mostly President Erdogan appointed judges to challenge the gist of the majority's significant findings. And I specifically focus on 2 famous freedom of expression cases against Wikipedia and Academics for Peace. But to put it briefly, the dissenters in their dissenting views really make vague arguments and do not explain why the majority of Turkish Constitutional Court was wrong. They wholeheartedly embrace almost all arguments uttered by the Turkish government to justify, for example, the ban on Wikipedia. And indeed, in many other politically significant judgments, a similar tendency of Erdogan-appointed judges of siding with the Turkish government is quite visible. So briefly put, in post-coup Turkish Constitutional Court, the use of separate opinions is a clear signal that the court is strongly divided along ideological lines. So to sum up, I think the findings of my paper have important implications regarding the judicialization of authoritarian politics. So I just want to briefly mention my tentative conclusions here. And I reached the inevitable conclusion that the judicial activism of the Turkish Constitutional Court in the post-coup period is curbed, and that the court has shied away from engaging in political controversies. For example, the court never ruled on constitutional challenges to the emergency decrees, which again, as I said, form the bedrock of regime transformation and dominance. And it almost certainly exercised judicial restraint because it would likely have resulted in a confrontation with the new political regime in Turkey. And the more the TCC, the Turkish Constitutional Court's regime supporting role become apparent over time, the more it retreated into subservience. So I think the only way out for reform-oriented judges in the Turkish Constitutional Court, of course, if there is any, would be to apply subtle pressure for political reform and wait until Turkey's authoritarian regime will weaken. Thank you so much.
Thank you, Emre, for this in-depth analysis of the role of the Turkish Constitutional Court in such difficult times, constitutionally speaking. So I now open the floor for the debate, for the Q&A session. So I invite our participants to use the raise hand function and to book for their intervention. Okay, I see that Josh Carton. So please, Josh.
I'll start my video now that you can actually see me. First, I just wanted to say I really enjoyed the panel and all three papers. As a former YCC chair, I never missed this panel, and it was a particularly good one this year. So thanks to all three of you. I only have questions for two of you, though, I'm afraid. For Ioannis, I think an interesting dimension to the comparison that I didn't hear much about in your presentation, and sorry if you do cover this in the paper, is that I'm not sure it's really an apples to apples comparison to look at a national Supreme Court and an institution like the European Court of Human Rights. I mean, the European Court, it isn't attached to any state. It isn't the branch of government of a state. And so it has a different relationship with the governments of the states, even if its judges are nominated by them. And I think there's a really interesting opportunity there to explore the institutional status of courts and tribunals, and here specifically national ones against international or transnational ones, and see how it might affect their decision making. So the question is, do you discuss this in the paper? And if so, what do you say? And if not, what's your sort of your quick reaction to that? And then a related question for Emre: how much of this is not specific to the Turkish example, but simply the phenomenon of judges protecting the vitality of their own institution? I mean, you can think of examples in much less politically charged context where democracy itself might not be at stake. And an American example might be the so-called switch in time that saved 9, when the American Supreme Court was striking down a lot of Franklin Roosevelt's policies to address the Great Depression, and Roosevelt threatened to increase the size of the court and appoint several of his own appointees. And then judges on the court seemed to change their opinion of the constitutionality of the New Deal, and preserved, as it said, preserved the number of 9 judges. Although we'll see if that was only a temporary preservation until the next few years. So thanks. Those are my questions.
Thank you, Josh. Please, Ioannis.
Yeah, thank you, Joshua. Thank you for this question. Yeah, this is extremely relevant, and it's a great point. And yeah, there is a difficulty in answering it somehow, because I sense that, let's say there's 2 ways or 2 planes that an argumentation could take place on. So one way of approaching this issue of comparing national jurisdiction to a court like the European Court of Human Rights, and what I actually did in the paper, is more to focus on the conceptual significance of the European Court of Human Rights, and to see how it is its jurisprudence is, and a case law is has quasi-constitutional impact for the contracting states, and that even when it doesn't, it eventually, the interpretations that it undertakes end up in a soft way influencing national judges and so on. So from, I think, the more, let's say, I think the comparison is valuable, especially from the level, if we are only focusing on the issue of the legal problem at hand somehow, let's say in abstraction of the more socio-legal or realist or institutional dimension of the issue, and we focus on just, so how does the case law develop, and how the different jurisdictions approach a question of balancing that comes to them with the obligation to provide some type of solution and some type of answer, then I think considering the impact and the influence of the 2 courts, I think the comparison, the juxtaposition is quite valuable. But it is true that this type of comparison operates on this level of a more, let's say, in a more positivist type of analysis. So if one would really start addressing exactly, like you said, the institutional ties that might exist in between the European Court of Human Rights, the judges, and the national state. So, in fact, or the absence of those, as opposed to, you know, the Supreme Court in the U.S. operating in the framework of a nation state, and therefore being perhaps more prone to be influenced by, let's say, considerations of government, as opposed to, so one, I suppose, could make the argument that, well, it is in a way easier for the European Court of Human Rights to proceed to, well, when there is no pressure to you know, satisfy some governments, to eventually be a bit more lenient with issues of freedom of expression of employees, and to accord a larger spectrum, a larger protection to government employees who disclose, who make unauthorized disclosures. But that would be a more, I guess, well, first of all, it would be hard to, I mean, I don't do that in the paper, so to answer the question directly as such, I think it would be interesting to see a more maybe socio-legal analysis or realist analysis that would perhaps do that. I think definitely there is value in that argument, and I actually would probably intuitively sense that it's right, what you're saying. But I do think, nevertheless, sort of defending the way I did it in the paper, that's still on like a conceptual level of trying to you know, see whether how this balancing exercise is undertaken by different courts. It's still valuable to also see that this level of a more like of higher abstraction, let's say.
Thanks. For what it's worth, I agree on the methods point. You wouldn't really know which questions to ask in a socio-legal analysis if you hadn't already done the conceptual work you have here.
Thank you so much. Emre, do you want?
Can you hear me?
Yeah.
Yeah, okay. Well, many thanks for the question. I think not just my paper, this whole literature on law and courts in authoritarian regimes have many implications for consolidated democracies. I think, for example, what I discuss in the paper as regards court packing in Turkey since 2010 has strong, you know, implications for what's going on in America, in the United States these days. So I think, theoretically speaking, I think we have to acknowledge that the distinction between authoritarian regimes and democratic democracies is somewhat, you know, blurred, right? So many consolidated democracies are borrowing from the playbook of authoritarian regimes, or vice versa. So I mean, these insights or many of the things that I discuss in my paper, because I to some extent consider the Turkish state as an authoritarian polity, has you know, has a great deal to contribute to the discussions in democracies. So to react to your question briefly, this is what I can say.
Thank you so much. I see that there is a hand raised by Seth Phillips. Seth, please.
Hi, this is a question for the Turkish case. I'm wondering if the Constitutional Court is a court on its own, because I'm doing a comparison for my graduate degree of, you know, constitutional courts in Latin America, whereas, you know, some of them are on their own, and while a few others like Venezuela are actually within the Supreme Court of that country. So I'm kind of curious if Turkey's Constitutional Court is its own, or if it's part of a bigger court.
I am truly sorry, but I didn't get the question. Is it a court?
I'll rephrase. So is it its own court, or is it part of a bigger court with, you know, other divisions?
Okay, the Turkish Constitutional Court is the apex court of the country, which
okay.
is the final step in the domestic judicial remedies.
Okay, Thanks for answering my question.
Sorry, it was a bit,
Okay. Can you hear me? Sorry. Can you hear me?
Yeah.
Okay. So if there are no other intervention, I have two questions. So the first one is for Ioannis. My question is, did you have the chance to look at the new EU directives on whistleblowing, which, if I'm not wrong, introduce a kind of different standard of protection than the European Court of Human Rights? And so here in Europe, we have this issue to harmonize the two degree of protection. So my first question is this one. The second is for Emre. Can we, because we are witnessing a general trend in comparative perspective in which we see constitutional court capture or quite toothless vis-a-vis the rise of authoritarian regime. So this is a more general question. Do you think that in an authoritarian regime, constitutional court can play any role, or is quite in the end ineffective when we have the transition from a democratic regime to an authoritarian regime? And the last question is for McGill. So my question is, because I studied a little bit the role of proportionality in assessing social rights protection. It is a huge debate dealing with the effectiveness of using proportionality and socioeconomic rights adjudication. So I was wondering whether you have thought about this. So the use of proportionality and the values of rights in this specific field of socioeconomic rights.
Should I go first? Yeah.
Yes.
Okay, thank you, Antonia. Yes, that's a good point, and it's actually the other paper that I'm publishing from the PhD is about the directive, so yes, I'm quite aware of it, but I think, well, it's important to note that the EU directive doesn't concern and explicitly excludes national security employees. So as such, let's say the topic of this particular paper unfolds in a different field, let's say, and it's a different debate. It's something that consistently has been excluded from EU legislation, and one can easily imagine why. Having said that, it's true that the standards of protection offered by the EU directive are high and quite encompassing also of whistleblowers in different fields. And what is important, I mean, it's beyond the scope of the paper I presented now, but maybe it's worth saying that one of the important things, if one is like in this like diverse panel, to like take one lesson home from this new EU directive of 2019 on whistleblowing, is that it expands the previous focus of whistleblowing legislation on solely financial matters, because there were previous also whistleblowing directives from 2015, for instance, that would protect whistleblowers disclosing, wire fraud or corruption in financial services and so on. It expands from that field to other legitimate interests that ought to be protected. Things related to, let's say, broadly speaking, sustainability, product safety, consumer protection, and so on. So in these cases, it asks from member states to establish a robust system of protection that includes both internal reporting mechanisms and external reporting mechanisms to some regulatory agency.
Thank you. Thank you so much. Emre.
Okay, you can hear me now? Because I have to, change the camera. I was using the USB camera. Now I'm, it's okay, right? You can hear me? No reaction?
Yes, yes.
Okay, perfect. So definitely whether, a constitutional court could play a role. I mean, I think it's a context specific case to some extent. Because in different contexts, different contexts bring up different, conditions, and whether it can play a role depends on that context. So I don't think I can give you a straight yes or no answer to that question, theoretically speaking. But the earlier research, for example, and I remember a number of, articles that was published in the, ICON. They focus, for example, on interventionist courts and their judicial behavior during these times or periods, so-called constitutional rupture periods. And I think in a sense, for example, the 2016 attempted coup created such a constitutional rupture moment. And the evidence suggests that the constitutional courts cannot play a major role. But I think, for example, because I can speak, about the Turkish Constitutional Court case, and in past constitutional rupture periods or moments, I can say that the Turkish Constitutional Court played a meaningful role, not a major role, maybe, to stop, for example, a government's drift toward authoritarianism, but what they did, for example, in the during the emergency periods in Turkey's Kurdish in the Turkey's Kurdish dominated region, for example, they were very careful with the review of emergency decrees, which is to some extent, can be regarded as playing a role. Even though, as I said, during my presentation, the relevant provision in the Turkish constitution prevents such a constitutional review of emergency decrees. So I think this kind of this question has some sort of broader raises broader issues. For example, what's at stake, for example, for constitutional judges. So to what extent the constitutional court was captured? Here, I'm not specifically talking about, court packing, because in the Turkish case, I don't think there was a court packing. But, in order to answer to your question, I think there are some additional questions or additional questions to be answered. But in the Turkish post-coup period, I think that the Turkish Constitutional Court, did not play a role because it did not want to play a meaningful role, because they do not want to, impinge on new political authoritarian policies needs, and then the inevitable conclusion for them was to, they retreated into subservience. Again, this is a very broad question. I think we have to, think carefully about some, related questions first.
Thank you so much, Emre. And last but not least, Michael.
Hey, I'm back. Yeah, so thanks. As you know, I'm someone who spent a lot of time working on socioeconomic rights, so that's very much in the background of my analysis here. There's a sense in which I'm not happy with this piece in that it's too negative. It's very much it's not spending enough time laying out my positive proposals, and I'm working within the framework of an existing dialectic. And as I move forward with this piece, I'd like to say more about what I think, but to move and talking about socioeconomic rights is, I think, one opportunity to do that, and it raises interesting issues. I mean, the short answer is I'm very much someone who thinks that if you are going to have socioeconomic rights, having some sort of proportionality safeguard in your courts is absolutely necessary. I think even if you're someone who is compelled by a constitutional equivalent of the international idea of a minimum core, the idea that a state has to fulfill that minimum core come what may, and that there can't be any justifiable reason not to fulfill that, just seems implausible to me. And I think if you look at much of the comparative work in socioeconomic literature, when you take a more absolutist conception of socioeconomic rights, you get really bad results, whatever your view on good results is. And just if I can put a plug in, you know, I have a book coming out called The Pluralist Right to Healthcare. It's coming out next year, University of Toronto Press, and the importance of safeguards like Canada's Section 1, which is our limitation clause, is central there. I should just say one thing, though. In saying all this, in the state of the dialectic I was talking about earlier, they have a concern about rights inflation as it being the case that rights are going to get implausibly broad scope and then be just justifiably infringed. You might think that given what I just said, there's this related rights inflation problem, that proportionality makes it easier to have constitutional socioeconomic rights. And if you think that they're a bad idea, you might think, well, there's a reason not to adopt proportionality. The only thing I'll say about that, because we're right basically on time almost, is that note that not all states that have proportionality adopt socioeconomic rights out of non-socioeconomic rights, and Canada is a perfect example of that, right? Yeah. Thanks.
Thank you so much, Michael. And so we are perfectly on time, and please join me in thanking our outstanding panelists for their papers and their presentations. And I just want to thank Professor Maximo Langer, who has been with us all the panel, and gave us a great support in organizing this panel within the American Society of Comparative Law, and also in organizing our 9th annual conference of the Younger Comparativist Committee that will be held on Saturday starting from 8 a.m. in the morning, and we will run until the afternoon. So thank you very much, and enjoy the rest of the American Society conference. Thank you very much. Bye-bye.
Thanks.
Hi, Antonia. Thank you for that.
Thank you, Massimo.
Everything is good, right? Are we good for Saturday? Is there anything you need with that?
No, just I mentioned to write to you because there is just a little change. You have another panelist instead of another one that cannot come. So I will make this little change, but I will write to you so that you have all the panelists and so on. But everything is fine. Yeah.
Wonderful.
Hopefully.
Yeah, hopefully. That's right. I mean, today, everything went fine, except that one of the concurrent panels, the person that was supposed to launch it from UCLA end, so that, you know, had the Pacific Standard Time in his calendar as opposed to so the panel launched in the end, but late, you know, really late, and I was desperately, this is why I couldn't really participate, because I was sending like literally maybe 20 emails, you know, in different directions to get the issue addressed, because I have a backup plan, but the backup didn't work, and you know, then I asked my assistant. Anyway, everything is going well, but yeah, anything can fail at any time, so.
The difference of time zone is an issue, because I checked my calendar, I don't know how many times this morning.
Yeah, I mean, I think I honestly, I should have just put the Pacific Standard Times, especially for local people, because what happened is that since we inherited this from BU, you know, when I launched it, you know, the program and everything, I was thinking still in East Coast terms, right? But and time, but anyway, If you listen, do I need to read any papers in advance or just show up for the?
So I have the papers. If you want to give a look, I can gladly send it to you. Yeah. Okay.
If you don't mind, if you remember, that would be great, because I actually think that, I mean, honestly, I'm not sure I will be able to read them very carefully, but at least to skim them before, in case I need to ask questions, to kind of keep the ball rolling in the panel on Saturday.
Okay, I will send you in a few moments. Yes.
Wonderful.
And, can I ask you something about the business meeting on?
Yes. We have other people here, but yeah, let's keep talking. Unless you see that they are 1, 2, 3, 4, 5, 6 other people. Okay. So we can talk here if you want, but I just mentioned it if it's something more, like that you want to talk one-to-one, I can send you an invite right away. We can create a new, or you can send me a Zoom meeting.
I think we can remove is impolite to remove. So I think that I don't want to take your time, because if you have a...
No, this is great, because it's equivalent of a hallway conversation, which we don't have, you know what I mean, in this setting. You know what we could do? Let me create a breakout room for the two of us. Create 2 breakout rooms. I hope people don't get angry. So I'm going to create one. You know what? It doesn't let me. Yeah. Okay, perfect. I will join you. I will see you now in the breakout room.
Okay.
Sorry, Antonia. What happened was that because I am the host, I cannot put myself in a breakout room, and it didn't let me join your breakout room because some of the people that are here did not accept the invitation. I think they just, and let me stop